Hi, I'm Jonathan Wood with Pacific Legal Foundation, and today I'm joined by my good friend and colleague, Anastasia Bowden, to talk about economic liberty. Anastasia, you've done some very important work at PLF defending the right to earn a living, particularly challenging occupational licensing. Can you tell us a little bit about why that work is so important and why these rights are so critical?
Yeah, this work is important because years ago, just 40 years ago, only about 5% of our nation required a license before going to work. Now nearly a third of Americans need a license just to do their job. This affects not just occupations that you and I would typically think of being regulated, like doctors or lawyers. It also affects such innocuous occupations as florists, applying makeup, cosmetologists, barbers, jobs that really present no threat to the public, and yet now require quite a bit of startup costs. And the problem is that these jobs would provide good entry-level positions to people who are trying to pick themselves up by their bootstraps and earn a living for themselves or their families. But they're being denied of that opportunity by overly burdensome and anti-competitive licensing laws.
So how burdensome are these requirements really? If someone wanted to, apply makeup, what do they have to do in order to get that license?
If you just simply want to apply makeup, which is something that women do every day at home without incident, you actually have to go through thousands of hours of training. And this just points to the arbitrariness of these laws. In some states, it takes more time to become a makeup artist or a cosmetologist than to become an EMT.
And as I understand it, this is a nonpartisan issue. Under the Obama administration, the White House put out a report saying that occupational licensing has skyrocketed the last few decades and is hurting the people who need economic liberty the most.
That's right, largely based on the empirical results of studies that show that licensing has come about not because there's really any need for it, but because the incumbent businesses have lobbied for it. People on both sides of the political spectrum are acknowledging that these laws are unnecessary, are burdensome, and as you said, are having a disproportionate effect on minorities, minority religious groups, minorities, women, and the people who can't defend themselves through the legislative process. And so, as you mentioned, the White House released a report saying that these laws are unnecessary and we really need to reconsider our policy.
Now, I know you've represented a lot of entrepreneurs prevented from starting businesses or their careers because of occupational licensing. What's the most outrageous example? What did someone have to do in order to get a license that's just absolutely ridiculous?
I think one of the most pernicious examples of occupational licensing are certificate of necessity laws, which we call competitors' veto laws because they essentially require entrepreneurs to ask their future competitors for permission before starting a business. So the way the law works is when you go to start a business, and this typically happens in the transportation industry and also the medical industry, you apply and the government will give all the existing businesses notice that you're applying for a license. At that point, they can protest your application, which subjects you to a government hearing in which you must prove to the satisfaction of a bureaucrat that you won't harm the existing businesses and that there's a public need for your business. These laws on their face aren't related to public safety. They're purely related to protecting the existing businesses from competition. And so we know that they're not protecting the public. They're just there to be anti-competitive.
So if you're an entrepreneur, how do you even try to do that? How do you show a bureaucrat that your business is needed and that you're not going to be, successful in competing against your would-be competitors?
Yeah, that's right. Even the best entrepreneurs can't prove in advance that their business is necessary. The way we typically find out if a business is, quote, necessary is by letting them open their doors and finding out. There's no magical graphs or equations that you can show to prove this to a government bureaucrat. And that's exactly what makes entrepreneurs so brave, is their willingness to stake their own funds and put in their own time and money to try to prove this and to take that brave experiment.
So, I guess the best example is obviously Starbucks didn't have to prove that we didn't need more coffee shops before it existed.
Yeah, that's right. And if you think about if we would apply that same reasoning to other industries, there wouldn't be so many of the innovations that we see today. If you asked BlackBerry if we needed the iPhone, BlackBerry would have said no. We wouldn't have the phone that many people love today. Mm-hmm. So it's really stifling new and creative businesses.
So a lot of these businesses, I think there's a pretty high turnover. Do you think the government has any role in deciding who gets to compete and whether businesses might be driven out of the market entirely?
Well, I think that the government is subject to regulatory capture, and that bureaucrats are they act in their own self-interest, and in reality, market forces are the best way of figuring out what's needed, what's wanted by the public, because it responds to public need.
So how am I supposed to know what company I can trust to move my stuff or to make me a sandwich if the government hasn't told me, who's good and who isn't?
Well, the great thing is that nowadays we have innovations like Yelp and Angie's List and things that immediately give consumer feedback to other consumers and allow us to rate each other and to see each other's ratings. I mean, if you think about 30 years ago, the idea of getting into a stranger's car and asking them to take you somewhere else would have been unheard of. It would have been thought that it was very dangerous. Nowadays, we do that without fear because you can see right away that this person has 4 stars, and we know that they're not going to put you in harm's way. So because of technical innovations, we have the ability really to police businesses ourselves.
And I think you mentioned the sharing economy and Uber. That's really one of the areas where economic liberty has really hit ahead, and the new technologies, regulations haven't caught up. Where's the future there? Is regulation going to prevent us from enjoying the next Uber?
Well, certainly whenever there are innovations in the market, the incumbent businesses are going to try to fight against that because it's contrary to their interests. But fortunately, I think because of the great consumer demand for these services like Uber, Airbnb, other innovations in the sharing economy, I think we're seeing that the trajectory is for economic liberty to win out.
I mean, great. I certainly love to hear that the forces of progress are winning. But where do we go from here? What do we do? Do we all need to file lawsuits and challenge bureaucrats?
Well, it's very difficult to win in the courts because of the low level of scrutiny that courts give to economic liberty. And that's something that we're trying to fight against at Pacific Legal Foundation. So while we do bring lawsuits and we think that's important and we want to move the law in a certain direction to set precedent so that government can't do these things in the future, we also work through the legislature to get legislative change. And we've been very successful in convincing the public and legislators that these laws are egregious, absurd, irrational, anti-competitive, and getting some repeal through the legislative process.
I understand you had some recent success in West Virginia defending the right to earn a living. Why don't you tell us a little bit about the reforms that happened there when you challenged the state's moving cartel?
That's right. We were representing entrepreneur Artie Vogt in a constitutional lawsuit against Certificate of Necessity law. So what happened was Artie saved up his life savings in order to purchase a moving company. He had started out of high school at this moving company at the very bottom, worked his way up, and eventually after several years had enough money to purchase the company with his wife Stephanie. What he didn't know was when he purchased the company, the authority to operate in West Virginia did not transfer with the purchase. So he was operating as the company had for 100 years. This company was very old, only to find out that he no longer had legal authority to operate. So he said to himself, that's fine, easy enough, I'll apply for authority. How hard could it be? I'm clearly qualified, I've been operating this company for a long time. But when he did, he ran into the state's competitors' veto law. And what happened was his competitors protested his application and he was denied. So we brought a constitutional lawsuit on behalf of Artie. And when we brought the lawsuit, there was a lot of publicity about it. And when it came to the legislators' attention about how egregious this law was and how it was affecting their citizens, they actually passed a repeal bill getting rid of the competitors' veto law. And so Artie calls this law Stephanie's Law in memory of his wife who started this whole fight with him.
Well, congratulations on that great win. But I have to admit, I'm fuddled by it. I mean, how could the state regulators look at a business that had been in practice for a while and clearly wasn't unhealthy or unsafe or destroying its competition? Given all the explanations you said earlier about the justifications here, why would they prevent this business from continuing?
Well, Artie's situation shows exactly why these laws are unconstitutional and why they aren't what the government says that what they are. The government says that these laws are aimed at ensuring that there's enough demand, they're ensuring that there's enough demand to sustain the businesses. But in reality, what we see is when there's a company like Artie's that has been operating, clearly there is enough demand because it stayed in business for so long. When they apply for the license, they're denied simply because their competitors protested. And so what these laws are a competitor's veto law. They have nothing to do with protecting the public.
I mean, so do you think there's any role for government here? Should it be anarchy and everyone gets to do whatever, I get to be a surgeon because I thought it'd be fun this week? Or how do you distinguish between those occupations that most people probably are okay with the government requiring a license for and, making floral arrangements?
Well, certainly we don't want to get rid of the law cartel because that would affect you and me. But no, I think we don't challenge laws like like licensing laws for doctors, or things where there might actually be a public safety rationale. But when there's laws that we know, because on their face they're related to being anti-competitive, pure and simple, those laws are unconstitutional and should be taken off the books.
So, what's the next step? Do we continue to challenge this in state by state? Is there something for the federal government to do or federal agencies to do to try to limit states' overregulation of economic liberty?
Well, certainly we will continue fighting in the courts, and we want to ultimately set precedent in the Supreme Court that government can't use its licensing power for purely anti-competitive reasons, and that these laws have to be related to public safety, otherwise they don't belong on the books. But other than that, we're really seeing a moment right now for economic liberty and occupational licensing. Several states across the nation are passing laws that are either getting rid of ridiculous licensing laws, like laws for florists or shampooing hair or mowing lawns in some states. And there's also laws that are being passed that create a barrier to these laws being passed in the first place. They make it more difficult for government to pass these laws, or they set up sunset provisions so that these laws have to be reconsidered after so many years. So we're seeing that at the state level.
Well, I know you've litigated a ton of these cases and you've testified in state and the legislatures. What do you think is the best reform? If you had your ideal state or federal legislation or rule to switch this so that people could have economic liberty, what would it look like?
I think the most difficult challenge that litigants face when they bring constitutional lawsuits challenging occupational licensing laws in court is the rational basis test. That test is meant just to be a deferential test, but in practice, judges essentially turn a blind eye to the facts, and they will uphold a law if they can dream up any rationale for a licensing law, even if the government hasn't asserted it during the course of litigation. And so it's a very difficult test to pass.
You basically have to prove a negative, right?
That's absolutely right, which is impossible to do. So you could only win when you have the most egregious facts, even when there are really good cases that really should win and shouldn't be on the books. So I think if we had a reform on that level to give economic liberty a higher level of scrutiny like it deserves, because it is so important, it would certainly make it easier for us to vindicate the constitutional rights of our clients in court.
So what should that different standard look like? Should the government have to prove its justification?
I mean, I think we could start with an intermediate level of scrutiny where once you've shown that a law burdens your right to earn a living, the burden is on the government to prove that there's a legitimate rationale here. Right now, the burden is on the plaintiff, but the government has all the information about why these laws are purportedly needed. And if they've made that decision, they should be able to prove it to a judge.
And that's how courts often protect constitutional rights, right? I mean, if you show that your rights are being impinged, the government has to justify what it's doing to you. Isn't that correct?
Yeah, that's right for all of the liberties that courts favor. I mean, that's true for First Amendment liberties and, things that the government or that the courts like. But somehow economic liberty has been relegated to a lower level of scrutiny, when in reality it's one of the most fundamental rights we have.
Mm-hmm. I mean, it's really the right that lets us enjoy all of our other rights. If we couldn't earn a living, what really could we do?
I think that's right. And there's an arbitrary distinction between rights when in reality they're all related. And in my opinion, rather than segregating out rights to see which ones are more important than the other and giving those ones more protection, maybe we should just put the burden on the government to prove that whenever it infringes liberty, it has a burden to prove that it has a good reason for doing so.
Well, Anastasia, I want to thank you for joining me today. It's been a fascinating discussion. Again, congratulations on the win in West Virginia. If viewers want to learn more about PLF and your work to defend economic liberty, how can they find out more?
Well, if your constitutional rights are being threatened, please contact us at pacificlegal.org, or if you're just simply interested in hearing more about what we do, you can visit our website, visit our Liberty blog, or follow us on Twitter.
If you enjoyed this discussion, please check out some of our other videos and subscribe to our YouTube channel so you never miss any of our updates. You can also learn more on our website, pacificlegal.org.